Are you going through the probate process in North Carolina because a loved one passed away recently and you're feeling overwhelmed? Tell me about it. It's complicated. My name's Tony Green. I'm your certified probate expert, or CPE for short. The CPE designation is intense training on the probate process and has helped me develop the skill set to find solutions for people going through the process every step of the way. We're here to discuss with you everything to do with probate in North Carolina, especially when it involves real estate. To be clear, I'm not an attorney. This is not financial or legal advice. It's for educational purposes only, from my experience and opinion as a realtor, appraiser, and real estate investor. Becoming a probate expert has allowed me to make a positive impact on my community, which is really important to me. So if you're looking for more information on probate, inherited properties, and estate planning, be sure to like this video, subscribe to the channel, and I also encourage you to join our Facebook group, North Carolina Probate Support. There's a link in the comments section below. So this video is a summary of the probate process in North Carolina. Probate is the legal process of administering a deceased person's estate and ensuring that their assets are distributed according to their will or state law. What I offer as a certified probate expert is being a resource for you. We have a vendor team that will help you through the process, whether that as an estate or probate attorney, a family law attorney, real estate professionals such as realtor, appraiser, or cash buyer investor, financial advisors, senior moving companies, clean up and clean out crews, estate sale companies, estate advance companies, and contractors for any repairs an inherited property might require. In North Carolina, the probate process begins with applying for probate and letters of testamentary. We'll include a link to the form below. It provides one form for both the probate of the decedent's will and an application for the letters by the personal representative, or PR. The person who died is known as the decedent in probate terms. The PR may also be called an executor. So as you can tell, probate gets complicated in a hurry with lots of different terms. Now back to the personal representative / PR / executor. In most cases, the executor is named in the decedent's will. So this form should be completed on behalf of the PR and submitted to the local county clerk of courts. When the PR files a petition with the court, he or she must provide certain documents such as the death certificate and the will. If the deceased person did not have a will, the court will follow the state's laws of intestate succession to determine who will inherit the assets. While it's good to know what will happen according to state law, this is almost never what you would want to happen in your specific situation. Therefore, you should always have a will as part of your estate plan. Not all property is subject to probate law. For example, in North Carolina, if you own a house jointly with your spouse, then they will inherit the house after your death without any court process. It doesn't always include things, it doesn't include things with a named beneficiary like retirement accounts, life insurance, payable on death accounts with banks or credit unions. So North Carolina law only covers property that you could include in a will if you had one, and not anything that has specific survivorship rights attached to it, like the examples I mentioned. Once the executor is appointed by the court, he or she will receive letters of testamentary from the probate court. These articles are extremely important for the executor, as he will need them to complete a number of probate tasks. The personal representative / PR / executor is the person responsible for managing the deceased person's assets, paying any debts and taxes, and distributing the remaining assets to the beneficiaries according to the will or North Carolina law. The probate process also involves providing notice to the deceased person's creditors and giving them an opportunity to file claims against the estate. This notice for creditors' claims against the estate must be placed in a newspaper qualified to publish legal advertisements, which is published in the county where the estate is being administered. Notice to creditors must be published once a week for 4 consecutive weeks, and should state that claims must be filed by a certain date, which is at least 3 months from the date of first publication of the notice. One of the primary roles of the executor is completing an inventory of all the decedent's assets. Knowing the value of a decedent's assets can allow the executor to divide the estate properly among heirs and account for every cent during this division. It can also ensure that the executor knows of any ongoing debts or bills the decedent owed. This is known as the 90-day inventory. So what is the 90-day inventory, you might ask? Well, the 90-day inventory, also known as Form AOC E505, is an inventory of the decedent's estate. The form for the inventory can also be found on the Administrative Office of the North Carolina Court's website. We'll include a link to the inventory form below. As the name implies, this inventory list is due within 90 days of the decedent's passing. However, the values on the form should correlate to the decedent's worth on the date of death, not on the date of filing. This is very important for tax purposes. The inventory lists all the bank accounts, assets such as cash, stocks, bonds, vehicles, real estate, or businesses and personal property as well that was in the decedent's possession at the time of their passing. And if real estate was owned, it is crucial to have an estate done for tax purposes. Again, the appraisal would be for the value of the property on the date of death. When there is real estate involved, you have to decide what to do with it. Are the heirs going to keep it and live in it? Or rent it? Do they want to cash out and sell it? And then if they want to sell the property, is it in good enough condition to sell at retail value? Or is it in need of a few minor repairs? Or is it major work that might need to be done before it can be sold? Or would the heirs prefer to sell it as is? If the property is distressed, the heirs probably would prefer to sell it as is. This is where our cash investors may play a role. No matter the situation, we have real estate professionals who can help. Additionally, my wife Kim and I are both realtors and investors, and as I mentioned previously, I'm an appraiser as well. If the will is contested, or if there's a disagreement among the beneficiaries, the court may hold a hearing to resolve the issues. Once all debts and taxes have been paid and any disputes have been resolved, the personal representative can distribute the remaining assets to the beneficiaries and close the estate. This can take months or even years in extreme cases. As you can see, the probate process can be complex and extremely time-consuming. So it's important to seek the advice of people who are familiar with the process. That includes an experienced probate attorney. We have several we work with in the Winston-Salem area, and we're glad to offer referrals to you. This video obviously doesn't cover all of the nuances of probate, but it's a good summary. Please comment below or reach out through social media if we can be of service. I may not be able to help each and every viewer, but if I can't, I can refer you to someone on our team who can. Thanks for watching, and have a great day.